You have the right to remain silent,
But we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law,
Spinning the Law
spinning the law, spinning the law.
with attorney Kendall Coffey.
All right, ladies and gentlemen, welcome back. Steve Malzberg, and I am happy to say that we are joined once again by the wonderful, great attorney, Kendall Coffey, author of a book by the same name, Spinning the Law. Hello, Kendall.
Hey, Steve, how are you? Happy Thursday. Happy Spinning the Law.
Happy, I thought you were going to say happy last day of spring.
That too.
All right, so the timing couldn't be any better. The jury has been seated as of a little while ago in the George Zimmerman case, finally. And here's what we have. We have an all-female jury where I'm told 5 of the women are white. And I'm also told that 5 of them are mothers. One woman, possibly the woman who's not white, has 8 children. She's originally from Chicago. So let's talk about these various things here, and let's look at it from a defense point of view. What does this mean to you as George Zimmerman's defense attorney that it's an all-female jury?
Well, I mean, there are a lot of other variables that the defense has been studying, and I would not say that gender is a predominant factor. But all other things being equal, it could be a slight plus for the prosecution. And I say that because if we accept as a starting point the prosecution theory of portraying Trayvon Martin as a young man, a teenager, somebody that a mom might feel needed some sympathy. If we just talk about the idea of people with guns, legitimate private ownership of guns, of course, but just attitudes about guns, carrying a gun with you, and there are plenty of women that do that. But I think that in balance, it's probably seen as a slight plus for the prosecution, but not an important factor. There'll be more interest in that, I think, from those of us who are commentators than there will be reality in the jury deliberation. I mean, I think what's going to be far more critical is man, woman. It is a difficult prosecution case. They don't have a lot of slam dunk evidence at all, and as far as we know, they have a couple elements that could be very significant. One of them is witness number 8, and remember her. She was the young woman who was apparently speaking to Trayvon Martin on his cell phone at the time of the beginning of the fatal encounter. And then, of course, we have that question still unanswered: is will the forensic audio evidence about whose voice was screaming on the 9/11 tape, will that prosecution evidence be allowed into the trial?
Right.
Those are the big factors, and they're going to be a lot more important in terms of how they play out than the gender of the jury.
And then we have, Kendall, of course, the medical evidence. I just, before I came on, heard on CNN that one of the women, I believe, has some kind of medical background, a medical technician or something, and she was playing up real big that they were saying in open court that the prosecution at least was implying that they have proof that the nose wasn't broken on George Zimmerman. He didn't go to a real doctor at first. He went to some other place, and it might not have been broken. But, I mean, to me, it's like, it's like, who cares if it was really broken or not? I mean, we saw how big it was when we saw the marks, and then, of course, we saw the marks on the back of his head. So, I mean, I would think that evidence would be huge for the defense, no?
Well, it's very important, and the jury will see it within their own eyes. You're going to see the pictures. The prosecution may try to slightly downsize it, but from a jury standpoint, the injuries are real. The injuries are graphic, and they're very consistent with the idea that, as George Zimmerman claims, his head was being pummeled against the ground.
Right.
And if the jury looks at those injuries in a self-defense case, you don't necessarily have to think the guy was on the verge of being fatally wounded to think that he had a reasonable belief that he faced the threat of death or serious bodily injury. He doesn't have to suffer serious bodily injury. He has to have a reasonable belief that he's facing the threat, an imminent threat of those kind of injuries. And the medical evidence dispute, even if on the margins a little bit's going to be disputed, The pictures, of course, tell the proverbial 1,000 words, and those 1,000 words are pretty good stuff for George Zimmerman.
Yeah, I would think so. We're talking to Kendall Coffey here on the Steve Malzberg Show. I know you're going to be doing a lot of stuff for NBC in their coverage of this trial. We look forward to that. Also, the jury selection, one more thing with the jury selection, and they were saying, if I have the story right, it's that they kept dismissing or striking white women after white woman after white woman. I think after 4 was struck, I think the defense objected, and 2 of the, from what I heard in the initial reporting on the TV this late this afternoon, 2 of the female jurors who got on who were white, the prosecution did not want. But the judge allowed in. At least that's what I heard. And also, people might say, why so many women? The judge actually said that overwhelmingly the pool or the resulting pool after they weeded people out were women. So you're going to come up with women, if not all of the 6, then certainly most of them would have been anyway.
And fortuity is a role in this. I mean, you don't get a mathematically precise allocation of panel members anytime you have a jury selection process, and there's a fair element of the random in who winds up on a particular jury. What Florida does, whether it's an attempt to exercise a peremptory challenge against a minority or a woman who is considered a special protected group within the meaning of Florida law, if one party is exercising a peremptory challenge, which means the automatic strike, you don't have to have any cause normally, the other party can say, wait a minute, I think you are improperly attempting to remove from the jury somebody who's a member of a special protected group, woman, black, could be Hispanic, and I demand an appropriate explanation. It's not rise to the level of a challenge for cause, but some plausible explanation for why you are striking this person other than the fact that she's a woman, or right, if it were a black, other than the fact that the person is black. And if the judge doesn't buy the explanation given, and based on what you described, it would have been an explanation by the prosecution, right, then the judge can reject and, in fact, overrule the peremptory challenge, even though peremptory challenges are otherwise entirely within the discretion of the party that is exercising them.
That's what it sounded like happened. Let me ask you one more question about this case, and we'll move on very briefly to something else, and that is the race factor. I keep hearing the media talking about the race factor, and the complaint, I believe, or the charge against George Zimmerman says that he profiled Trayvon Martin, and it doesn't say racially profiled. It says profiled, which of course has implications. And I mean, if in fact, George Zimmerman ever took the stand, or the defense admitted, he looked suspicious. He looked like he was wandering around. He had a hood on, and it was raining, but he looked like the kind of guys who have been around robbing the place before. It had nothing to do with his race, but he looked suspicious to me. Is that somehow a negative for him, or is that just common sense?
It's common sense, but it can certainly be spun, as the prosecution would spin it, to say that George Zimmerman, and they're not even claiming it's a racial profile, but George Zimmerman was going after him. And what they would say is George Zimmerman decided that this guy was trouble, with a capital T, decided to, in effect, become a self-appointed police officer, even though the dispatcher told him not to, and that therefore the fact that George Zimmerman was pursuing him, I mean, that really becomes the issue. That raises an inference that it was George Zimmerman that actually began the physical confrontation. Because remember, if George Zimmerman simply walks up to somebody and says, "What are you doing here?" in effect begins the verbal confrontation. Right. There's nothing wrong with that. That doesn't remove in the slightest your ability to invoke self-defense and stand your ground. What would cause Zimmerman to lose his ability to invoke the laws of self-defense if he began the fight?
Right. Well,
it really almost comes down to who threw the first punch. And that may be one of the questions that we never
Right, because there's no witness. The only witness is Zimmerman. I mean, there's no other witness.
And he may take the stand. Some people think he may not take the stand. So that's another one of the giant questions to be answered in the coming weeks. Will he take the stand?
Yeah, it's going to be very, very interesting. Okay, the Supreme Court, they're making us wait, Kendall, I think to the last possible moment of next Monday, which I think is the last day of their session. They have not weighed in on affirmative action. They have not weighed in on the Prop 8. They have not weighed in on DOMA. Today we got a ruling on basically a case that said the federal government cannot require that groups using federal money to combat HIV or AIDS have to also oppose prostitution and sex trafficking. In other words, I guess the federal government can't dictate exactly what the beliefs of a group that are doing some good. They can't dictate that they do everything according to what the federal government wants. I guess you'll explain that. But why are they keeping all this for the end, do you think? Now, and let me ask you this. Are these cases decided before the, not the arguments, but before the questioning that we all hear? When they hear the case and the lawyers make their cases, both sides make their case, and it's all publicized and all, has the decision already been written and or just at least made on the part of these judges, and that's just for show? Because that's what I'm hearing from some people.
I don't think the decision certainly hasn't been written, and I doubt it's been made.
Okay.
I think they go in there, each of the justices perhaps with a preliminary or tentative conclusion, but
right.
there's no decision made until after
okay.
the
well, I'm glad that got cleared up.
A very, very close case, oral argument can be the game-changing play. What we've seen from the Supreme Court saying, and it was actually Chief Justice Roberts saying, we can't make groups that are receiving federal funds pledge allegiance. He used the word pledge an allegiance to a particular set of beliefs. Now, you can certainly say, hey, if you do anything that supports prostitution, human trafficking, anything like that, even in the slightest, you don't get federal funds. But we can't make you declare a certain philosophy or ideology, even one that is a very good thing, in order to get federal funds, because that's what we're trying to respect your First Amendment rights. And whatever you say about this court, liberal, conservative, sometimes a mixture, it is a strong First Amendment court, Steve. I got to tell you, we've seen consistently strong validations of the First Amendment. The very controversial Citizens United,
right,
at the end of the day, was a First Amendment case. And you know, there's a lot of division about whether that was a good thing or bad thing. That's the one that gave corporations a great deal of latitude in terms of political contributions. But you know, people that are First Amendment scholars understand the underpinnings of that case. We recall this really detestable kind of hate demonstration near the funeral of a Iraqi war veteran.
The church, drawing a blank on the church, yeah.
But you remember the hate-mongering demonstration that they did?
Absolutely, yeah.
By the First Amendment.
Yep.
So this Supreme Court is going to be remembered for a range of different things, but certainly one very, very strong champion of First Amendment rights. And next week, boy, that's going to be a big week, Steve. Well, I hope we have a chance to talk about some of.
I do too. You tell the judge in your case to cool it for another week so that we could chat next Thursday. You say
I'll do it.
You say I demanded it.
I'm going to get a letter from you, Steve.
All right.
Thanks so much.